It's just gone 1 o'clock now, so we'll begin. You're very welcome, everybody, to this afternoon's webinar, which is looking at emergency care orders for children. And for you, those of you who don't know me, my name is Niamh McCarthy. I am head of the Parental Advocacy and Information Services for Parents of Children in Care, which is a service delivered by Barnardo's. And we operate a national information and advice service, which these webinar series are part of. And we also have face-to-face advocacy in Dublin North City, Waterford and Wexford. I'm joined today by Stephen Cahill, who is the Managing Solicitor in Chancery Street, which is the Legal Aid Board. Today we're going to be discussing emergency care orders, and I'm going to put a number of questions to Stephen. We probably will be just under the half hour or bang on 30 minutes. I do encourage everybody, please use the chat, and please, any questions that you would like or clarifications or anything, please, we're modifying it as we go along all the time. At the end, there'll be an opportunity to give feedback on our feedback sheets. All of these webinars are recorded, and we have a series, I think, this is our 10th with the Legal Aid Boards, 9th or 10th, and there's other webinars with psychologists around parental capacity assessment and also with guardian ad litem. So there's a whole series of webinars there as a resource that people can access at any time, and I'll put the links in up at the end as well, but Sylvia will probably put the links in the chat as well for everybody. So you're all very welcome. So Stephen, when we were thinking about emergency care orders, we were thinking about why would that happen? Like, in what are the circumstances that a parent or a family may be issued with an emergency care order?
Sure. So procedurally, I suppose there are two separate ways that an emergency application can be brought to the district court or in which it arises. The first circumstance is where a member of An Garda Síochána has invoked their powers under the Child Care Act under Section 12 to remove a child from the care and custody of a parent. And they would do that where they have formed the view there's an immediate and serious risk to a child. So that's the first set of circumstances, is that a guard has intervened and then it transfers to Tusla, and Tusla have to bring an application. The second approach and the second way an application is brought to the court is by the child and family agencies. So the social workers themselves apply directly for an emergency care order where they are of the view that there's an immediate and serious risk to a child, and they themselves have brought the application to the court that didn't require Gardaí intervention, for example.
Okay, and if we just look at the first scenario, for example, so the Gardaí have come across a situation and they feel that the child may be at risk, so they've made a decision to make an application to the courts or remove the child there. Is there a delay in then that happening? Does it go to court immediately on the same day, or what happens for the family in those circumstances?
So if a guard has come across an emergency circumstance and has invoked their powers under Section 12 to remove a child, they then are obliged to deliver the child up to the custody of the Child and Family Agency immediately. So it isn't the guards who actually bring the matter to court. They then are just charged with keeping the child safe and transferring the child to the care of the agency. And then the agency must either return a child to their parent, or if they're not returning a child, then they have to apply immediately to the district court for an emergency order.
Okay, so that's a great point of clarification then, Stephen. So it's actually always the Child and Family Agency, or Tusla, known as Tusla, that will bring the order to the court. So if I'm a parent in that situation, and I accept that there's many different types of situations why an emergency or where an emergency order might be applied for, or if I'm a parent in that situation, I presume I'll receive notification that an emergency care order is being sought. And will I be able to attend that hearing?
Yeah. So in principle, an emergency care order application is to be brought on 2 days' notice to a
Okay.
parent. So notwithstanding the obligation to apply immediately, there has to be, in theory, 2 days' notice to a parent. Now, the reality is that requirement is always waived, and it's generally accepted that if it's an emergency, it needs to be heard immediately. But a parent should always be served and notified of an application being made to court where possible. There is provision under the Act for the Child and Family Agency to apply what's called ex parte, which means not on notice to the parent. But that's a
Okay.
very, very high bar, and you would require very particular circumstances to justify such a serious application being made not on notice to a parent, and with the parent not being given the opportunity to attend court, to engage, to instruct lawyers, and so on.
Okay. In when For some of our parents that we work with throughout our service, one of the common scenarios that comes up is when a parent is going through a pre-birth assessment and they're engaging in that assessment with the Child and Family Agency. There is some concerns and risks identified, and a plan has been put into place that the child will go into the care of the Child and Family Agency. However, when obviously the parent, a mother in this case, or the parents, the mother goes in and gives birth, it's usually then it seems that it's an emergency order that is being sought. If the child is being removed from the hospital or going straight into care from the hospital. And I suppose, is there any other alternative to that in that scenario, or is that always the way it must be for
So,
newborns?
so when you're dealing with a newborn, the fundamental obstacle is that no application can be made until that child is actually born. So even where the Child and Family Agency might have the gravest of concerns, they can't apply until the child is actually born. And as you've noted, this should be a measure of last resort, and there should be the pre-birth conferencing and all alternatives explored. But even post-birth, and even if the CFA have serious concerns, a child can only ever be removed from a parent and placed into care, either with the consent and agreement of the parent or by way of court order, or if a guard has to invoke their powers under Section 12.
Yeah, because I think for new parents, it's particularly traumatic in those hospital settings, in particular, we think. But in terms of the threshold for an emergency order, what it would be the threshold to get the order?
So for the threshold to be reached for an emergency care order is a high one. The court has to be satisfied that there is an immediate and serious risk to the health or welfare of the child. So that risk has to be present at the time of the making of the order. So it has to be proximate in space and time. It can't be a future apprehended risk. It has to be an immediate, so a risk to the child as of right now, and that risk has to be very, very serious. So it's a very high bar to be reached. And I think acknowledging that, to go back to the newborn instance,
Yeah.
quite often what happens is an application for an interim care order would be applied for, and that might be adjourned to allow the parent time to adequately instruct lawyers and whatnot. And usually it would be sought for the child to be maintained in whatever hospital they were born in until that application can be determined appropriately. And then if something were to occur in the meantime, like if a parent were to try and abscond with the child or something like that, then an emergency care order application might be brought, or Section 12 might be invoked.
Okay, that's very interesting. So am I right in thinking from our previous conversations as well, Stephen, that um, the parent can't make the application for legal aid or representation until the order has been sought either.
No, so we would always try and emphasize that early advice is key and is always of huge benefit. A parent can apply and should indeed apply to their local law centre for advices at any stage. So you don't
Okay.
need to wait until there's an application. If there's any Tusla engagement or apprehension or fear of Tusla engagement or applications being made down the line, we'd always encourage a parent to attend at their law centre and instruct their lawyers to get early advices and appropriate advice about how to engage with the child and family agency and ultimately how to try and avoid the risk of facing any applications being made to the childcare court.
Mm. Yeah, because we see across various different sites, very different situations for new parents or parents of children going into care from the hospital or in newborn babies. Some are very well, like, are well supported to attend court hearings, and some are not well supported and don't have that legal representation, and it can be a very overwhelming time, especially if they're recovering from a surgery or a very difficult birth as well.
Yeah, absolutely. I mean, it's going to be extraordinarily difficult for any parent facing an application in respect of their newborn. But you would hope that between TUSLA, the social workers, medical social workers, that the parent could be assisted in even making applications to the legal aid board or to a private solicitor, and then be supported in being able to instruct their lawyers thereafter and to attend court. But yeah, unfortunately, there is a difference in approaches sometimes taken.
And is there the opportunities for parents to attend court virtually in those circumstances as well?
Yeah, parents can be facilitated. Any party can be facilitated to attend remotely. Ideally, one would be able to come to court, but that may not be medically possible. But where the Child and Family Agency, for example, may be able to support attendance,
Mm.
even simple things like providing taxis and things like
Yeah.
that. So you'd always hope that a parent can attend course which would allow them to better engage and instruct their lawyers. But if they can't, then there need to be alternative arrangements put in place for them.
Yeah. And then the other kind of question that came in when we were looking at this topic was really around then unaccompanied or separated children coming into the country. So when a child is separated from their parents, who may be in a different country, or they're fleeing war-torn countries, are do separated children, do all their applications go under an emergency? Is it an emergency care order that's applied for in those instances, or is it a different type of order?
I don't think there's any set process. There's nothing to stop applications being made under either Section 13 for an emergency or under Section 17 for an interim care order as the initial application. TUSLA alternatively sometimes don't look to receive unaccompanied minors into care. Rather, they seek to what's known as accommodating them under Section 5 of the Act, which can be quite problematic, I suppose, as well.
Yeah. And just for our attendees, Stephen, what does Section 5 mean?
Apologies. So that effectively provides a lesser form of protection, basically, for that young person than if they were received into care under a statutory order. So Section 5 basically keeps the matter outside of court, and its use is somewhat controversial, and I think is certainly open to challenge in the higher courts at some point in time.
Okay. So should be used as a very short-term measure if it's used at all.
Yeah, its very use at all is for unaccompanied minors isn't universally agreed upon by commentators and academics, it is a very legally complex matter, um, and it's not something that I'm aware has actually been brought to the
Mm.
attention of the higher courts at this point. But I think it's certainly open to challenge.
Okay. I suppose a number of scenarios came up. So around the birth of a newborn, unaccompanied minors, but also another um, scenario that came up was when a parent had to leave suddenly, so that they had to go to it was a medical emergency, or and there was no identified kinship carers or family friends or that, so very short term, or possibly going into to receive treatment, or possibly serving a very short sentence, custodial sentence. And in those cases, if it is an emergency because their child needs care, but one of the fears parents expressed was, if an emergency care order was sought, does that mean you automatically go on to an interim care order? And would the courts be aware that this was for a short-term measure?
Sure. So emergency circumstances like that, medical issues do frequently arise. And you would always hope that someone would be able to put forward, or that they'll have some sort of friend, family member, as it kinship care, who could step up just for that short period of time while the parent is incapacitated. But if you don't have appropriate arrangements and you're not able to put in place appropriate arrangements for your child, then unfortunately some sort of Tusla involvement is likely to be necessary. It doesn't follow that it would have to be an emergency care order, for example. Um, a parent could agree to voluntary care for a certain period of time. So that is where a child is received into care with the consent and agreement of a parent, but not under a court order. And that agreement only goes on for as long as a parent continues to agree to it. So that could very clearly be prefaced on the idea that this is just while I'm in hospital and need to recuperate for a short period of time.
Yes, yeah, yeah. So that makes sense of where voluntary agreements are really useful for both parents and the Child and Family Agency as well.
Precisely. So for the courts to interfere, there has to be a sufficient element of what's deemed parental failure. And it's hard to see how a medical um, matter that's arising would amount to that, and where voluntary care would suffice. I think it'd be more appropriate to try to keep that out of the court arena. You're right to put that parent's fear to bed, that it's not going to run the risk of an emergency order and then subsequent interim care orders applications being brought.
Yeah, yeah. And in your experience, Stephen, is it most likely in the case of emergency care orders that the next step is an interim care order?
They are separate and distinct applications and orders. The usual process, however, is that if an emergency care order is granted, so that's an order that can last for up to a period of 8 days. So if that order is granted, the Child and Family Agency will routinely issue an application for an interim care order returnable to the last day of the order, so before it expires. But that doesn't mean that they're going to go ahead with that application. It can
Okay.
just be a way of protecting their position. So if an emergency order is made, hopefully the agency would be able to meet with the parent, assess and address whatever concern arose, and allow then for a safe return of the child. And then that application for an interim care order falls away or isn't proceeded with.
Okay, so I suppose some parents would come to us and say that uh, they lose a lot of hope if it's in the case of an emergency, that their children, or there's a high level of risk identified at the very beginning. So I suppose it's very hopeful that there still can be a lot of work done with the Child and Family Agency to avoid a longer stint in care as well. Um, I suppose just to kind of summarize, Stephen, I think the key messages are regardless of any scenario, it's really important to get legal advice at a very early date. So contact the local law offices and get that legal advice based on person's circumstances, because they're also individualized as well. That it's important to note that an emergency care order has a high threshold to be met as well. Like, the courts need to be satisfied, as you said, that there is a reason that the parent can't care for their child, and it has to be a current reason as well, not, if I understand correctly, not historical.
Yeah, or not even future. So it's not even that they have a fear that something might happen in the future. The risk has to be of immediate occurrence as well. So yeah, it's a very high bar.
Okay, and then that it is, where possible, parents will be notified and can attend court as well, and that accommodations should be made if possible to help the parent to attend those courts and give their instructions to their solicitors as well. And notwithstanding, these are really difficult cases. One of the other scenarios that came up but wasn't as common was really about if a parent had had to go, say, into for hospital treatment, or was going abroad for some reason for a number of weeks or months, very short term again, had made arrangements for their child, but those arrangements didn't work out, and Tusla had to step in for whatever reason, and the parent wasn't aware of these situations. Um, when they return, then their child is in the care of the Child and Family Agency. What would your advice be there?
So if Tusla have had to step in, I suppose, unbeknownst to a parent, the obligation in the first instance is going to be with Tusla to try and notify a parent. If an application is brought to the court, the judge will want to know, have the parents been notified? And if not, why not? What steps have been taken to notify them? A judge might find themselves in a situation where, okay, that application may need to go ahead because
Yeah.
whatever arrangements were put in place have fallen away. So an emergency order might be made. I suppose reflective of the fact that it can be unforeseen circumstances. An emergency order can only last for 1 week. And during the currency of that week, again, the Child and Family Agency should be trying to take any and all possible steps to notify the parents, to engage with them, to try and assess an appropriate and safe return of the child. If that can't be done, then the agency, I suppose, would almost certainly have to apply then for an interim care order once the emergency is expiring. But they'll have to try go through the same steps again, and the judge will want to know again what steps have they taken to notify a parent. So parents should be notified as soon as possible, and once they are aware, if they're aware the child's been received into care, they should immediately begin to engage with the Child and Family Agency and also seek immediate legal advice.
Right. And just, Stephen, you said there that the emergency care order can only last the 7 days, 1 week. Um, and a second emergency order can't be applied for consecutively after that. Okay.
There's nothing in the statute, so in the Childcare Act, to actually stop a second emergency application being brought. But the practice is it is never done. It has been discussed in the higher courts, and there's no firm answer, yes or no, but the reality is it is never done. So once an emergency care order is made, the child then must either be returned to the parent upon its expiration, or a subsequent order for an interim care order must be brought, or an application must be brought for it.
Thanks very much, Stephen. I think they were all the questions parents had came to us with, and the different scenarios that were being faced in relation to emergency care orders. I'm sure we'll think of a million more questions, but there doesn't seem to be any questions in the chat at the minute. So it's just 25 minutes past 1. So I might thank Stephen for joining us today, and thank you for sharing all your knowledge with us as well. It's really interesting, and I suppose it's really good to break down that piece. But I suppose what's really important is that key message of getting the proper advice and access to the proper information and understanding the nuances of all this, which is really key. I'm just going to put up a slide now for everybody just to share our feedback form. Again, please, any questions you'd like to put Stephen, please put in that feedback form as well. And access to both the legal aid website and access to our own website, the Bernardo's Parental Advocacy Service, and access to our previous recordings. So I'm just going to share that QR code, and I'll thank Stephen for his participation today. Thank you.
Thanks very much, Niamh. And as ever, if there's any further questions, I'm more than happy to get back to anyone after this is finished.
Thanks, Stephen. Okay. Again, I'd like to thank everybody for attending today, and hopefully, we'll be sending out the invite to our next webinar which will take place next Thursday. Thank you.